Hello, and welcome back to Coin Lady channel. We have some breaking news. A congressman has written a letter to Kim Jong Gensler, and I love it because he isn't asking Gensler to do anything. He's essentially simply tossing the good news that Judge Torres sided with Ripple against the SEC in Kim Jongler. I like how he's throwing the ruling back in his own face. This is a wonderful sight. And he shares his aspirations for the SEC's eventual evolution as well. But this letter isn't trying to accomplish anything, as I'll explain as I describe why I like it so much. Simply put, it's gratifying. For the XRPs among us, you're going to like it so much more, holder. This is the sort of thing that can impact public opinion, so I shouldn't claim it's literally going to do nothing. In terms of how it affects Gary Gensler personally, this has gone viral on social media, and I do feel it is significant. Perhaps I lack confidence in the theory, but I have faith in the bigger picture. Yeah. It's going to be a good time, so I'm going to fill you in on the details. But I should clarify that I am not backed financially in any way before continuing. You shouldn't buy or sell anything based on what I say. I'm not a financial advisor. Okay, I'm just a fan that occasionally posts videos to YouTube about crypto-related stuff for the heck of it. Now, before we get into that, I just wanted to point out that there's a headline in the screen from the crypto industry's foremost lawyer, Max Keiser. XRP receives clarity. Max Keiser, gigantic Bitcoin maximalist, highly toxic. Keiser is the last person you want to have involved in the cryptocurrency industry because he makes us all look like idiots. But, unfortunately, he is representative of a certain subset of Bitcoiners who are equally poisonous. On June 10th, little over a month before this most significant verdict, he tweeted some encouraging news for XRP and XRP. Max Keiser said that while Deaton will fight tooth and nail for its customers, the company's founder has to know that XRP is a worthless cryptocurrency. And there you have it, that tweet is as refined as a glass of exquisite milk because it contains aged mica. And so, lawyer Bill Morgan retweeted that, saying it hasn't aged well over the last 5 weeks. In addition to the judge's ruling that XRP is not a security, the coin itself is not worthless. Bitcoin is no longer unique in its transparent nature. Oh, no. This is obviously not the outcome that Max Keiser was hoping for or anticipating. Whether you agree or not, the fact remains that XRP is the only large-cap cryptocurrency with a transparent protocol. In a technical sense, Bitcoin does not. Morgan, the lawyer, has heard that Bitcoin is no longer the only currency that can be understood. Technically, the SEC hasn't decided on this, but everyone, including Kim Jong Gensler, is treating it like it is, so it seems pretty damn close to being touchable and palpable at this point. Oh, I almost forgot to mention that, I haven't heard anyone else nearly say this either. What I find fascinating and pleasing about the decision in SEC versus Ripple is that the SEC messed up by trying to do too much. Because the subject of whether or not XRP is a security was not one with which Judge Torres was charged under Rule 2, it was not necessary for her to provide a ruling on the nature of XRP. And to be honest, I didn't believe Judge Torres would bring it up at all, nor did most of the lawyers I was following. The thing is, she actually did it. Why? Why did she do what no reasonable lawyer would have done? Is there any logical reason for her to argue that XRP is not a security? Because the SEC proposed the embodiment theory, which argues that XRP itself is a security, in the first place. That's a pretty significant assertion, and if it's accurate, it could have repercussions for how Judge Torres makes her rulings in other cases. Since the SEC raised the issue, Judge Torres was compelled to comment on the embodiment argument, and she finally ruled that XRP itself is not a security. So, consider what may have happened if the SEC hadn't gone too far by essentially stating that the token itself is the security since it incorporates all of the efforts of Ripple and so on and so forth. Judge Torres almost definitely would not have addressed the issue at all if the SEC hadn't overreached by proposing the ridiculous embodiment argument that XRP itself is the security. XRP's legal status would remain murky. What I'm getting at is that Judge Torres was well within her rights to determine that XRP is not a security because the SEC had so egregiously overreached and repulsively trying to make up regulations as they went along. In what ways is that gratifying? In my opinion, things can't get much better than this. Look at this. Richie Torres has tweeted something. Also, Torres the resident surname. In my knowledge, that is merely a coincidence. To be clear, this is the actual serving congressman who penned the letter to Kim Jong-un. I will only discuss politics on my channel if they directly affect crypto or money, and I always give credit where credit is due. Simply put, I won't be giving my 2 cents on political issues unless and until politicians stop talking about crypto money and start talking to me about it. This station does not air political programming. Not only will it never preach to you about anything unrelated to politics, but it will also never preach about anything at all. No one else does either, at least not unless it has something to do with crypto or the economy. But again, the only reason they start doing it here is for political reasons. So, I wanted to stress that I am happy to give credit to anyone, whether they liberal or conservative, Democrat or Republican. Whatever you're doing seems right to me. If you're worthy of attention, I'll give it to you. If not, I'll make sure you know it. Now you may applaud a Democrat, Representative Richie Torres, for standing up for what's right. He appears to be strongly advocating for XRP investors. Repertory Torres is really grateful to have found yet another advocate on our side, and thanks you very much for your support. So he gave me a copy of the letter, which I'll read aloud in a second. And a Republican named Warren Davidson retweeted it. As for his state of residence for our listener's profile, I keep forgetting. Perhaps it's not on the list. But in any case, he is also a member of Congress. The replication make obvious that Congress needs to offer clarity that is needed for investors, entrepreneurs, regulators, and even the courts, he tweeted. I still have faith that we can come up with a bill to regulate the digital asset market that will get the job done efficiently and correctly. That settles it, then. If you're doing the right thing, it doesn't matter to me. Whether you're on the left or the right. Attorney James Murphy, also known as the Metal Lawman, retorted to Warren Davidson, I'm going to say it, and if you're not, then I'm going to say that. Right, there it is. Oh, I did have it with me. Oh, kumbaya, let's gather around the campfire. A Republican from Ohio has retweeted a Democrat from New York named Richie Torres, suggesting that reasonable crypto legislation may yet be possible. The way things are going, though, he does have a point, and I will need to elaborate on this in future films. However, events are taking place. And if you look at the government's response as a whole, they are quite anti-crypto. It's intriguing, and the choice by pharmacies may have opened a door. However, I want to elaborate on that in a forthcoming video. Then the chief legal officer at Coinbase, Paul Gray, put up a brick wall. And he tweeted out the Torres theory, which is what is cited here from Representative Richie Torres, an exceptionally lucid exposition of Judge Torres's jurisprudence. Here is a tweet from Attorney Bill Morgan, thank you very much, Representative. Know of what the SEC decides, the part of the ruling you refer to as the Turing Doctrine will be upheld. That the judge sided with us is consistent with many subsequent cases, and we wholeheartedly concur. Therefore, the claim that XRP is not a security is correct. There is no miraculous solution that will make that irrelevant. Representative Richie Torres's latest illustrious missive to Kim Gensler can be found below. I guess it goes as follows, cheer against the deer, and I adore it. It's very funny, since he's not even trying to get something from Ginza. It's like spitting in his eye, and it feels good. What I mean to say is, after reading the recent ruling by Judge Annalisa Torres of the Southern District of New York, I am writing to ask if the SEC intends to recognize the absurdity of the Commission's fight against crypto assets. Obviously, regulation through coercion fared poorly in the court system. That's the honest truth. Gary now prepares to learn the answer. Do you have any idea how badly the SEC blew it? He hasn't even made a request. And then, he states that in a landmark legal judgment, Judge Torres resoundingly rejected the regulatory overreach of the SEC by highlighting the requirement to prove the presence of an investment contract, ruling that the SEC has been treating all crypto assets save Bitcoin as securities without regard to their specific nature. A return to a strict application of the Howey test, which has been used lazily in the past, may be seen in Judge Torres's reasoning. By the SEC, have less damaging remarks been spoken? Without a doubt, the asset represents the efforts of rippling in its whole, according to the embodiment theory. No, there aren't any rocks hiding it. Yeah. Sloppily. I appreciated him saying it because that was quite the jibe. Far worse than that, in reality. I suspect ill will was the motivation. So that I may take it gently, I shall do so. Not stopping now, though. Indeed, the most recent court ruling sets forth an unmistakable rule that deserves to be known as Judge Torres' Rule 4, bringing much-needed legal clarity to the turmoil of crypto legislation. Like Torres' doctrine argues that while cryptocurrencies alone do not meet the Howey test's definition of a security, they can be marketed as part of investment contracts that do. It is now clearly evident to the SEC, thanks to Judge Torres' ruling, that digital assets are not securities in the abstract and that the SEC lacks the legal jurisdiction to oversee digital assets absent a concrete security offering. The SEC maintains its right to appeal the district court's judgment, but the likelihood of an instant appeal is extremely low because there are still outstanding concerns in the case. Time is needed to find the facts, through a trial, in order to resolve them. Stop the note for now. While it's technically possible for not only an appeal request but also, like, the appeal to be accepted, I personally find the likelihood to be quite low. That concludes the recent discourse on the topic. Interlocutory means what exactly? Appeal? That's the word for it, at least I hope so. I hope I expressed myself well. To be fair, while I'm not watching YouTube, I'm not practicing law. Since the representative has ruled that a trial must still take place, the only sort of appeal that may be requested at this point is an interlocutory appeal, which can be filed before the period when it would normally be reasonable to do so. After doing that, you can generally send the appeal paperwork. However, in order for this to be an interlocutory appeal, the court, in this case Court Torres, would have to give his or her stamp of approval. And usually only if you can establish that something was taken wildly out of context will those be authorized. Also, something crucial was left out, misunderstood, or overlooked. They'll need to convince the judge that something really serious went wrong. This is quite unlikely. The judge seems quite sure of herself, in my opinion. Therefore, it's quite unlikely that anything will occur. In any case, the representative says, the persuasive authority that the tourist's concept will likely command in future judicial cases will limit the SEC's ability to make up the regulations that go along. The case against Coinbase has a shaky legal basis, and it has been properly dismantled. Judge Torres issued findings of law and criticized the SEC for failing to provide the cryptocurrency business adequate notice while Chair Gensler was in charge. No rule or clear guidance about crypto assets has been released by the SEC. When questioned about Ether's status as a security chair, Gensler has been all over the place, contradicting himself and even the Commodity Futures Trading Commission, CFTC, at various points. There's a chance it may be both. Therefore, the SEC has opted to convey and regulate not through rules or advice, but through enforcement actions, which are often strategically timed. The enforcement actions themselves, as well as the constant stream of contradiction and confusion, are everything but fair. And I am certain of this. Here. A Democrat has come out and said that actions made by this government, which, let's be honest, is the Biden administration, are bad. He requested firearms, and as he is in control, he was granted them. He is discussing the importance of time in politics. This is the political position he holds. He gets props for pointing that out. I don't think anyone with an ounce of intellectual honesty could disagree with you that the current administration is fundamentally opposed to cryptography and the crypto community as a whole. That's why I refer to them as anyone for short. I also want to stress that this has nothing to do with identifying with the left or the right. Who is right and who is wrong is at issue. Amazingly, I think the last administration was equally as bad. Oh, my beer was dented even worse, Biden thought. However, I must give him credit for being brave enough to make such a statement. He continues, I look forward to learning how the SEC will reassess its regulatory assault on crypto assets in light of the Taurus doctrine, before saying, I hope that the SEC will find itself so chastened by the court's decision that it will concentrate the Commission's enforcement energies where they belong on the bona fide bad actors who perpetrate serious transgressions like fraud, market manipulation, and the misappropriate one of customer funds. Well, that settles it. My heart leaps at the thought. Simply put, you sucked Ginza, and hence you lost. I'm shoveling it down your throat. Now what are you going to do? Well, that settles it. I write it. It's great, you should see it. If it came from Congress, it would be great. Then, in a few videos soon, maybe even today. Perhaps, hopefully, tomorrow. I just really want to get into the ramifications of this, because you suddenly notice, like the sum of its silence, like I'll say that some of it's just like this concept of deafening silence. There has been a temporary lull in the outcry and pontification from those in positions of authority about how terrible this government is. What a peculiar turn of events. Could they be rethinking their next steps in light of the recent events? Happy moments. You shouldn't use my advice to buy or sell anything because I'm not a financial expert. Please like and subscribe my channel. See you later, bye.